Hello, I'm Professor Harper, and welcome to another lecture from Journalism and the Law and Ethics. Today we're going to be talking about intellectual property, uh, which, in essence, what you need to be concerned about are three things: copyright, patents, and trademarks. But really, when the rubber meets the road, you have to be concerned about copyright to protect your work as a freelancer and perhaps as a member of an organization, and also to be concerned about violating the copyright of others when you write materials or publish photographs or use video. So while this isn't covered under the First Amendment, which we've been, or the Fourth Amendment, or the Fifth Amendment, or the Sixth Amendment, the Bill of Rights we've been working with, copyright was so important that the founding fathers put it in the Constitution in Article 1, Section 8, that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right of their respective writings and discoveries. So it's right up there. Actually comes in the Constitution and not as part of the Bill of Rights or amendments to the Constitution. So obviously it was important to the founding fathers. Now, copyright laws, there have been many changes over the years, but they basically have expanded and extended the rights of the creator. And then the Berne Union extended copyright internationally. One of the more recent um, additions was the Digital Millennium Copyright Act of 1998, which extends international legal remedies through the World Trade Organization. Now, the protected works are literary works, music, dramatic works, pantomimes and choreography, pictures, graphics and sculptures, motion pictures and audio-visual materials, sound recordings, and architectural works. Now, the right of the copyright holders has been extended over time, and essentially it's to reproduce the copyrighted work, to prepare derivative works based on the copyrighted work. So the ability to take something and make it using the same basis and making it different, to perform the copyrighted work. So if you're in a rock and roll band, um, if you play a cover, technically you're supposed to be paying someone for the use of that copyrighted work, or if you write your own music, you should get some payment for the use of that. To display the copyrighted work, to obtain royalties from those who use the copyrighted work. A length of the copyright, as a general rule, it extends for a long time. So it's the lifespan of the author plus an additional 70 years. You don't need to renew your copyright. And for materials before 1978, the term's going to kind of vary, but essentially it will protect the author for as long as he or she lives in a few more years for the family. Unprotected works, ideas, procedures, processes, operational methods, works that have no original authorship, names, short phrases, and slogans, although they may be protected under trademarks. Um, as an example here, the name of one of the books that I have written was, and that's the way it will be, news in a digital age. And so it was done for New York University Press, and when New York University had a big conference on this, I said, shouldn't I get some credit? And they said, no, that's not our problem. You can't copyright that. U.S. government publications cannot be copyrighted, and works already in the public domain, the copyright has expired. So probably many of you, when you were in high school, had um, plays and various novels that were from Penguin Books. And these are works that are already in the public domain. Moby Dick, The Sun Also Rises, Shakespeare, Milton, stuff like that. The copyright has expired. Parody and fair use is one big thing which we see in libel cases, the Hustler case, for example. But if you remember from the first week, second week actually, when you took the legal research quiz. Campbell v. Acuff Rose Music was an example where Roy Orbison had written and sung a song, pretty famous one, "Oh Pretty Woman," walking down the street, etc., etc. And then Two Live Crew did a parody of it. Fortunately, their song didn't do as well as Roy Orbison's, which was a lot better. But Roy Orbison and his company sued for copyright infringement, and the U.S. Supreme Court said, no, it was to make people think and laugh or whatever, and so it wasn't seen as as long as it was parody, you were okay in terms of usage. Videotapes, DVDs, computer softwares, the court has basically determined that you can have one copy for personal use, but more than that, you're going to be in trouble. We don't really have to worry about videotapes anymore, and to a certain extent no longer have to worry about DVDs, but computer software used to be the case, and I don't know whether this is still the case, but the Justice Department would come in and to large corporations and see whether they had pirated software for things like Microsoft Word or Microsoft Office. And if you don't pay for a license fee for it, they faced huge fines. Music and file sharing, this was a big thing 15, 20 years ago, where the recording industry successfully sued for copyright violations in a variety of cases with Napster, Kazaa, Grokster, Morpheus, and so it is illegal to have file sharing of this type, and that's why you have iTunes and various other file sharing for music where you pay a fee. Trademarks are somewhat different, so they're recognizable symbols, trade names like Ivory Soap, Sears, the unauthorized use of somebody's name like Tiger Woods. And the courts have found that a poster reading "Enjoy Cocaine" was similar in script to Coca-Cola, so enjoy Coke rather than enjoy cocaine. So you couldn't do something that's similar. Ringling Brothers Circus, which just closed shop not too long ago, the greatest show on earth, could not be used by a car dealer which called itself the greatest used car dealer on earth. When it comes to the World Wide Web, there's something called cyber squatting, which means that individuals have taken internet domain names of products or companies without authorization. Relatively easy to get that fixed. But if it's parody again, and parody really covers a variety of sins, Jerry Falwell, the religious gospel guy that was involved with the lawsuit with Hustler, jerryfalwell.com has protection, except when it comes to defamation or libel. Now, here's a real tricky one when it comes to journalists, and it's called the fair use doctrine. And when I was working in television, basically the notion was that you could use 1 minute of material, up to 1 minute of material from that you didn't own the copyright to for news purposes. So if there was an obituary of a famous person and you were doing a video obituary of, say, Fred Astaire, for example, who was a very famous dancer, you could use up to 59 seconds of his movies without paying the movie company or his estate money. Well, it's a little bit tricky. So that there's no precise formula, but it's usually less than 10% of a literary work or less than 500 words, which is lower. Less than 1 minute, as I said, used in broadcast news, but if it's outside of like Entertainment Tonight, they actually have to pay oftentimes for the use of video clips from movies unless they're doing a review. So if it's within a news program, you can get away with it. It's a little bit on the line when it comes to non-news programs. Fair use does not allow use in entertainment programs, as I said, including news magazines on television like 60 Minutes. and it does not allow the use on websites of content, photographs, recordings, and other protected material without authorization or a limitation on amount of words or time. And I realize that we all do it all the time, where we take a screenshot of a photograph and we put it up on our blog, or we put it up on our Facebook with comments, and technically there's a violation of copyright there. The big companies are not going to come after you in most likelihood, but you are violating copyright. And if any of you have ever done uploading of material to YouTube, YouTube will essentially challenge your right to use certain music, for example, because you don't have the copyright for that music. I played in a rock and roll band when I was young. We did some original recordings, and actually I had to go through the YouTube process to claim copyright on one of the songs, because there was someone else who claimed the copyright for that material. Fortunately, I won, but you need to be aware of that. Advertising and public relations, it's commercial speech, which has, as you know, has less protection under the First Amendment than journalism. There's not a lot of litigation with respect to public relations, although copyright violation, trademark infringement, and insider trading all do apply to advertising and public relations. There is, some administrative and government authority over this. So the Federal Trade Commission has authority over deceptive advertising, and does create rules with respect to advertising. And the case that's involved here, Supreme Court case, Central Hudson Gas v. The Public Service Commission of New York, it essentially what happened is the company advertised its rights and its rates, in a competitive nature, and the commission ordered it to stop. And the court test here, which came out of this, still applies. So is an ad true and not misleading? Is the government's interest substantial? Does regulation advance government interest? Is there a specific connection between the government and the advertising's goal? And is the regulation no more extensive than necessary? So these are some of the things that you need to keep in mind when it comes to copyright issues, trademark issues. And I think that the guide here is be careful when you use someone else's material. It may not seem as though you're doing anything wrong, and maybe you're not. But most times when you use somebody else's material, you need to be concerned about whether you have copyright clearance to use the stuff. So thanks very much, and we'll see you online.